Thank you, Representative Spiller. I was surprised to see the Attorney General mentioned in a bill about prayer in school. On page 3 of the bill, it says a school district can have the Attorney General provide legal advice, and it requires the Attorney General to provide that legal advice on how to implement school prayer, and the Attorney General can even design the program at a school district. My question is, what laws are we so worried public schools might violate when implementing this bill that we are preemptively getting the state's top law enforcement official involved?
I'm not really anticipating a problem, but I think it's important to know that schools and school districts and charter schools have the protection and support, knowing, because as serving on a school board in the past, knowing that someone has their back, not only to defend them, provide them guidance if they choose, which the guidance can come from the Attorney General's office or their own legal counsel in developing their policy for each particular district, but also to know that the state would back them in the event in the event necessary in the legal process.
I mean, I've worked on a lot of education bills in this body, and I rarely see us preemptively getting the top law enforcement official involved in a school program. Are you concerned that school districts may violate the Establishment Clause of the United States Constitution?
Not under this bill. No, I'm not. In fact, this bill was designed and drafted specifically to not be in conflict with the Establishment Clause and be primarily in line with the Kennedy versus Bremerton School District case.
Then why does your bill guarantee that the Texas Attorney General will defend schools and districts in court on the taxpayer's dime if they get sued for violating the Establishment Clause?
Because I think, here's a fair question, but I think what's going on is because of the Lemon test and the Lemon case that has been the law and been interpreted since 1971, is that there is a fear, and there's still the ghost of the Lemon test is still there. And so there's uncertainty, there has been in the past, about what they can do and what they can't do. And so I think that providing for this coverage and providing for this defense by the Attorney General is, I think that that's welcome to school districts, knowing that the state of Texas has their back in upholding current Texas law.
To participate in the period of prayer, parents have to sign a consent form, is that correct?
Correct.
And I'm certainly for parental consent, but I want to make sure I'm reading this correctly. Parents have to waive their First Amendment rights under the Establishment Clause of our Constitution when they sign this consent form?
They waive any claims that they may have by allowing their child, or if it's a guardianship situation, to allow that child to participate in this program. So by doing so, they are waiving their rights and claims that they would have against the school. In other words, they are allowing them to participate, but they can withhold that or withdraw that at any time and the child not participate.
Why would the government ever encourage parents to waive their constitutional rights?
Well, under my bill, the government's not encouraging them to do that. It is, but
why would the government ever give parents the option to waive their constitutional rights?
Well, we waive rights all the time. We waive rights in the courtroom. We waive rights in criminal cases. We waive them in civil cases. We waive them all the time. That's nothing new.
Are there any other instances where parents must waive constitutional rights to participate in a school activity?
I would argue that every time your child comes home with a note to go on a trip, and there are certain waivers that you sign with that to the school, anytime, I mean, those things are commonly done to have a waiver of rights. Whether those be constitutional rights or not, I don't know. I've never looked at it from that perspective to study whether they might be constitutionally protected rights or not.
Why would you add a provision to your bill asking parents to give up their constitutional rights if you don't think your bill is unconstitutional?
Well, number one, it's not unconstitutional under federal law or under Texas law, and it's just that added protection for the school, knowing that they can provide this for their students and for staff that choose to participate without living in fear that they're going to be sued.
I want to switch to a separate part of your bill, Section 2, which I believe is actually the most important and consequential part of your bill. Am I correct that Section 2 of your bill amends Section 25 of the Education Code, which currently states that, quote, a person may not require, encourage, or coerce a student to engage in or refrain from such prayer or meditation during any school activity? Is that the current statute?
The current statute is yes, it shall not require, encourage, or coerce.
And is it true that Section 2 of your bill would amend this language by removing the word encourage from that section of our law?
Correct.
So I'm trying to understand, why does the bill strike the word encourage from that section of law?
Well, because, as I mentioned, the Lemon case and the Lemon test, and which is a three-pronged test. I don't want to get bogged down in legal jargon, but that has been in place for many years. And one of the components of that, one of those prongs of that three-pronged test, had to do with advancing religion, that the law must not have a primary effect of either advancing or inhibiting religion. So if and to the as the Lemon case has now been overturned, therefore that advancing portion is no longer applicable. And so this is just bringing the other statute, 25.901 of the Texas Education Code, in line with existing law. That's the only reason that that's changed.
So, but this change to Texas law in Section 2, the change to a student's constitutional right to pray during any school activity, will apply to schools regardless of whether or not they adopt the period of prayer that's in Section 1 of your bill. Is that correct?
Yeah, I mean, that particular statute has been in place since 1995.
Right, 30 years.
And those rights are granted, but there was a limitation on those rights, and one of the three limitations had to do with the word advancing, or to encourage. And so to the extent encourage is in line with advancing in the Lemon test, which has now been repealed, it's inappropriate to have that in the statute anymore.
I understand, but what I'm saying is Section 1 applies to school districts that choose to adopt a period of prayer given all the restraints. Section 2 applies to all school districts across the state of Texas, not just those that choose.
Gentleman's time has expired.
Mr. Speaker?
Yes.
Mr. Talarico, for
Move
what
to
purpose?
extend the gentleman's time.
We are in the last 10 days of session, and there are no extensions.
Mr. Speaker?
Mr. Talarico, for what purpose?
I raise a point of order against further consideration of Senate Bill 11 under House Rule 8, Section 1A1, on the grounds that the caption does not give reasonable notice of the bill's contents.
Please bring your point of order down front.